saying that basically our courts have been usurped by these corporations because they're hiring the courts for the day, and they've usurped our courts, and they're being supported by these treacherous and corrupt judges who, knowing what they're doing, are doing them, and not on their oath of office. So I'm going to arrest them. And I told the judge before I wrote to his legal advisor saying if he sat before me and was behaving unlawfully, then I would be arresting him on that day. And so she responded saying, your comments are noted but not accepted. Documentation available. And so then when I turned up in court, what he'd done is he bottled it, and he got 3 magistrates. Well, magistrates are just lay people; they're volunteers. Listen, man, they're just trying to do their public duty. So I unfortunately had to tell them, listen, explain the details, and unfortunately, I'm sorry because I thought it was going to be Judge Morgan, you know. But you're going to do your job today, or I'm going to arrest you. And so the choice is yours. And well, my words, I will arrest you if you don't do your duty. So they retired. The advantage of that was after Birkenhead, because we'd had such an awakening of what happened. The advantage was when the magistrates retired to their room, the police officers, which shouldn't have even been in the courtroom really, but I mean, we're in there. We're talking to John, and they were saying, "Well, how do we process these people?" You know, because what we're saying is this: if you listen, it doesn't matter if there's 100 of us in the court, and there's a judge telling us that something's lawful. If we can prove that he's behaving unlawfully, the police should arrest him. Then they're not the jury. They're not the judge. They should arrest the people that they believe are breaking the law. And if it's the judge, then arrest the judge.
Welcome in. Welcome in. Thank you for joining me today. I wanted to show you guys this document that I found online about administrative courts. And this is coming straight from a judge who has been in the courts or working for the courts for 81 years. That's a lot of time to dedicate to the court system. And I'm guessing that she got to a point where it started to weigh down on her conscience and she felt like she wanted to tell the truth to the public. Now, I'm going to briefly read over this document, but if you want a copy of this document, just email me and request it and I'll send it to you, because this is really just showing that our work and all of the research that we're doing is not in vain, and is proving more that this system is a system to trap us into, especially through administration. Even when it comes down to guys and, well, it's also women, but that are on child support or paying child support. If it's not done through family court, then it most likely is administrative, and that is unconstitutional. So let's go through this briefly. And like I said, if you want a copy of this, just shoot me an email at divinetrustbabies07@gmail.com, and I will send this to you so that you can have it for your own studies and you can review it for yourself. But let's start. Judge rules administrative court system illegal after 81 years. Well, it has been a long time coming. Let me zoom in so you guys can see a little bit better. Hold on. Zoom in. All right. Let's get into it. Well, it has been a long time coming, but all along there have been discussions behind closed doors, never in public, that the administrative law courts established with the New Deal were totally unfounded and unconstitutional. With the anniversary of Magna Carta and the right to a jury trial coming up on June 15th after 800 years, the era of Roosevelt's big government is quietly unraveling. Now, if you guys don't know, Roosevelt was the president who enacted the Emergency Banking Act of 1933. He is directly connected to the bankers, aka the criminals. So he had a big hand on confiscating the gold from the public. He is the one who produced the order to collect the gold or tell the people to turn their gold in as an executive order. So keep that in mind. A federal judge's ruling against the Securities and Exchange Commission, which is known as the SEC, for using its own administrative law judges in an insider trading case is perhaps the beginning of the end of an alternative system of justice that took root in the New Deal. Constitutionally, the socialists tore everything about the idea of a democracy apart. It was more than taxing one party to the chairs of another in denial of equal protection. It was about creating administrative agencies, one, delegating them to create rules with the force of law as if passed by Congress, sanctioned by the people. Two, the creation of administrative courts that defeated the tripartite government structure, usurping all power into the hand of the executive branch, as if this were a dictatorship run by the great horde of unelected officials. Not discussed in the coverage of this story is that the administrative law courts are a fiefdom. I never seen that word before in my life, to put it mildly. We need to look up the definition of this. They have long been corrupt and traditionally rule in favor of their agencies, making it very costly for anyone to even try to defend themselves. If someone were to attempt this feat, first they have to wear the cost of an administration proceeding and appeal to an Article 3 court judge. Then they must appeal to the Court of Appeals, and finally plead to the Supreme Court. The cost of such adventures is well into the millions, and good luck on actually getting justice, because it's not about justice. Literally, these Article 3 courts are put into place as banks. They are offshore banks, basically, and they are dry dock vessels. So whenever you step inside of their courthouse, you are under their jurisdiction just by walking through those front doors. The worst part about it is when you go inside of that courtroom and you walk inside that gate where you are enclosed with the judge, the prosecutor, or whoever else will be up there, the stenographer, and all of that kind of stuff, and the clerk. You are putting yourself basically under them. So you ever heard of this saying, the ball is in your court? That's what you're doing. You're putting the ball in their court. However, when you do have the understanding, or should I say comprehension and knowledge of how to fight jurisdiction, you know how to get out of certain things, even if you go inside of that courthouse, okay? So that's why I say that it's very important for you to do your due diligence and study this outside of the information that I'm giving you so that you can make sure that you fully comprehend this. Because you never know when you might have to do this. But the fact that someone has been like a judge that has worked for the system for 81 years has come out and is telling the people that this is what's going on, it's no way that anybody can say that none of this is true or that we are crazy or anything like that, because at this point it's been proven. I don't know what else they want. I'm gonna keep reading really quick, but like I said, if you want this, just email me and I'll give it to you. Furthermore, administrative law courts cannot sentence you to prison, but they do every fucking day. That's the crazy part about it. There are people literally behind bars behind administrative court. It's crazy. And it's because they don't know their rights. And I always tell you, he who fails to assert his rights has none. That is a maxim of law, and it is a very true one, because if you don't do it, they're not going to tell you, well, you know, you don't have to do this. They don't want to tell you that because they know that as long as they can connect to that social security number, that birth certificate, and have you as cheap labor, they're going to do that because it's putting money in their pockets in the system to keep it going. These judges take an oath to uphold the Constitution, just like the police officers. However, they don't do it. So we have to do that as the people. We have to hold them accountable for their lack of upholding the oath that they took. Okay? Their first priority should be to make sure that everything is constitutional. However, because the bankers have sneaked their way into the system, it's two different jurisdictions. And they're going off of the one that is statutory. Okay? So the lack of criminal prosecution meant the judges did not have to be lawyers. Okay? They could be anyone's brother-in-law looking for a job where he just rules in favor of the agency not to be bothered with law. Unless the victim has a pile of money, there is no real chance that he or she can afford to defend themselves. This is why the agencies cut deals with the big houses and prosecute the small upstarts who lack the funds to defend themselves. In a 45-page ruling, United States District Judge Lee Martin May in Atlanta issued an injunction halting administrative law proceedings against Charles Hill, a businessman who the SEC accused of reaping an illegal $744,000 profit trading in Radian System stocks. This is typical. The legal fees involved will exceed the amount of money he is alleged to have made. The typical result is to just pay the fine and they go away. It is cheaper. The judge ruled that the SEC agency violated the appointments clause of the Constitution by subjecting Hill to proceedings before an administrative law judge, who isn't directly accountable to the president, officials in charge of the SEC, or the courts under Article 3. The ruling is 81 years overdue. The entire structure of administrative agencies blackmailing people has been outrageous. Then you take the banks who just entered a plea of criminally guilty to manipulating markets. They are now formally felons who engage in violating SEC rules, and thus, under the SEC rules, they are no longer eligible for a banking license. The banks are too big to jail. And the SEC has waived their own rules, of course, to exempt the banks, which is completely illegal. But the fact that these banks have more power than the government itself, everything is always going in favor of the bankers. And this is why I stress the fact that you want to be a banker. We didn't create this game. And however, we all landed in this game. We're on the game board and we don't know how to play the game. So once we learn how to play it, we play it the way they've been playing it all these years to be exempt and to be living in freedom, true freedom, outside of this paper slavery, right? So we're doing what they're doing essentially. This is why you want to be a private banker at the end of the day. So they can engage in fraud and manipulation, get caught, pay billions in fines, and the SEC exempts them from losing their licenses. This is how corrupt administrative agencies really are. There's a book here called Truth's Victory Over Tyrants and Tyranny by John Lilburn. If you guys want to go check that out, I think you can find it on Scribd. And that's spelled SCRIBD.com. And you can sign up for a free 30-day trial to get this document. And other books, they have a lot of stuff on there. And you can access it for free for 30 days. Just make sure that you cancel that subscription if you don't want to pay the $11.99 a month for it. But when you go to cancel the subscription, it will ask you if you wanted to take advantage of another free 30-day trial. Go ahead and do it. But make sure you cancel if you don't want to pay before that second 30-day trial is up. I'm going to finish right here. And then, like I say, if you want a copy of this, just email me. The new decision calling the administrative law courts what they really are is reminiscent of the notorious extrajudicial proceedings of the Star Chamber operated by King James I. The Court of Chancery set up outside of the King's Bench, so there was no trials by jury. It had the same purpose to circumvent the law. This is where our Fifth Amendment privilege came into being. That came about following the trial of John Lilburn from 1615 to 1657 for handing out a pamphlet the government didn't like, which was censoring his freedom of speech. Crazy, right? So without delay, we're going to get straight into it. And I'm going to just talk about how administrative court is all about jurisdiction. Really, it's about making money. As long as you stand under them and you give jurisdiction to them over you, and you act in joinder to the all caps name that you think that you are, they're going to take advantage of you. It's just like somebody who has ill intentions, and their intentions all along was to take advantage of you. If you allow them to, they will. Ain't that what people tell you? Ain't that what your parents told you? If I know a lot of women heard men are opportunists, and I don't fully agree with this. I believe there are men and women opportunists, but that's a whole nother discussion. But they said men are opportunists and they'll take whatever they can if you allow. They only will do what you allow. That goes for the court. The courts, the judges, the lawyers, all of those that are involved in Article 3 administrative court proceedings will only do what you allow. That's why if you fail to assert your rights, you don't have any, because they're not going to tell you. Their job is to collect payment, okay? And the payment is not even the money that you're sending to them, because that money holds no value. They are promissory notes, right? The payment is when you sign the documents in the court that they can go and get securitized. All right? That's making you the debtor. That's why they write in black ink. Black ink is dead man status. All right? Let's get straight into it. Disclaimer. The information presented in this presentation does not belong to me. I am not the creator of it, and I do not own it in any way. I'm a private being that has studied various United States laws, codes, statutes, and Admiralty maritime jurisdiction. I am not and would never be a lawyer, legal aid, or attorney. This is not legal advice, but it is lawful. I have executed many processes for myself. The info included in this presentation should be fact-checked before executing anything. Anything you execute is at your own risk and that alone. Studying and learning as much as you can about this process is advised because the more you know, the more you grow. I'm going to stand on that to the day I stop breathing. All right, so administrative courts. The judiciary comprises two types of court venues. A corporate administrative court, which is all for the corporations and collecting for those corporations. It doesn't really care about you. It just cares about getting that payment and getting you to act as the corporation, the all caps name. This is why their summons are written in all capital letters in black ink. Okay. And common law court of record, right? And that is the common law court. That is the court that only operates from the supreme law, which is our inalienable, and unalienable rights. And I've been saying that word wrong, and so I just learned how to properly say it. So yeah, those rights cannot be given or taken. They come directly from the creator. So those courts are Supreme Court and Chancery Court, things like that. Okay. A judge is an administrative court. A judge in an administrative court does not act judicially, but as an administrator to settle contractual disputes. A judge in a court of record sits judicially with a jury of people to remedy harm to other living people. The courts are attended by commercial list judges, some of whom are designated as jury judges, able to sit in a common law court of record. Okay. Common law acknowledges the lawful rights possessed by living men and women. Statutes prescribe legislation to administer artificial legal persons. So that is the difference. Common law only will go by the rights of a living being, which is the supreme law of the land, okay? It comes directly from the creator. Harm nobody or their property. Point blank, period. Outside of that, everything else is fiction. Statutes prescribe legislation to administer artificial legal persons. So they are only put in place so that they can go after the legal fiction for the corporations. And when you, the living man or woman, acts as that all caps name and go into joinder with that fiction or artificial legal person, then they're going to put their statutes over you. Okay? And that's their jurisdiction, which means you understand them because you stand under their jurisdiction. A statutory administrative court is for commerce and practice, which means de facto. It is a place of corporate banking, offering a dispute resolution service for consenting parties, where living men and women unwittingly consent to be party joined to an artificial legal person, obligated to settle the accounts of commercial adhesion contracts. That's how they get you. They get you to act in joinder so that you can become the debtor. And debtors can only owe because they cannot create. So once you act as the debtor, you automatically owe the debt. Okay? And that's why they trick you up with all those questions in that legalese terminology. The judge does not sit judicially, but acts as a corporate administrative officer. Administrative courts are not sanctioned by Parliament and are not part of the de jure, which is fact, laws, and usages of the realm. All administrative courts are unlawful because they do not have a jury present. So if you've been sent a notice for child support or any type of summons for a traffic citation or any of that type of thing, where they're summoning the person, which is the all caps name, you don't have to consent to that. You literally can write over that notice that you do not consent to those proceedings, and you are not that person that letter is addressed to. You get that notarized and send that to the courts, the clerk, the justice of the peace, the attorney general, the secretary of state, internal affairs. You send those out and it will disappear because you're already telling them that I'm not that person, and they can't argue that with you. They're not going to. They're not going to tell you you have the ability to do that. However, they're just going to send you those notices and threaten you. And most people, because they believe that they are that all caps name, act from fear. I've never been to jury duty because I'm not that person. Before I even knew that I wasn't that person, I just knew I wasn't going to jury duty. And my entire family were afraid. And when they got those summons, they went. And they always say, if you don't go, you'll be arrested. But I've never been arrested. So it's all about what you know. Any court without a jury present is an administrative court. The law is absolutely clear on this subject. There is no authority for administrative courts in this country, and no act can be passed to legitimize them. And that comes from Halsbury Law 2011. And I do want to start talking about Halsbury Law a little bit more in some further YouTube videos, because I think that that's something that you should know about. Especially if you're somebody who has had issues with judges and courts and all that kind of stuff. You want to know as much as you can about this so that you can stand on your square. A common law court of record is for justice with a jury in law, which is de jure, fact. I'm moving too fast. It is a place of real world criminal evidence where a jury of one's peers, and the peers have to be someone like people who actually know you. These have to be people that you've interacted with so they can speak from a place of who you truly are, not just random people who've been summoned to come in. Okay? A jury of one's peers examines what is true and fact in order to determine what is right or wrong, just and fair. The parties are living men and women, and their decisions attempt to remedy harm or loss suffered by one or more injured parties, and to provide protections for living people in their community of life. The judge sits judicially. The only venue of justice for a living man or woman is a constitutionally sanctioned common law court of record with a jury of one's peers. A common law court, de jure, with a jury, is the only venue of justice for a living man or woman. So if you are considering yourself as sovereign and you are a living man or woman and not that all caps corporation that was created to make you think you are that, to make you the debtor, but you're actually the creditor, then as I said, when they send you these summonses, you don't ignore them because that's acting in dishonor. And if you ignore them, they're going to move forward with proceedings. And this is why you will get a warrant put out for your arrest, because you didn't tell them that you don't consent and you are not that person. Administrative courts operate on assumptions and presumptions, which is things that aren't fact, right? Everything about it is fiction. It is a story. It's a play. Literally, it's called the theater of commerce. It's a play for commercial businesses. The Crown makes the presumption that you are acting in joinder to the artificial person name. When you answer to the name, you are joining the action involving the name, such that the man or woman and the name are joined in a single case. But that case is in legal fiction commerce in the Admiralty Maritime Jurisdiction, which is the international law of the sea. Having joined the case by your agreement by conduct, there is the presumption of your implied agency for the named vessel, example, John Doe in all caps, on the sea of commerce, including your willingness to settle its account liabilities in court as the trustee of the vessel's estate trust, example, Mr. John Doe Trust, all caps. Okay? Whereas, as an aware man or woman, you are the rightful controlling agent, beneficiary, executor / executrix for Mr. John Doe Trust in all caps. You are not the liable trustee. They are. So they switch roles with you when you act in joinder. The debt comes off of them and goes on you. So let me give you an example. Say, for instance, you got a traffic citation and you dismissed it with my method that I showed you how to do. Somebody has to pay that debt. However, it ain't going to be you. It's going to be the cop that wrote that citation. Now they become the debtor and they owe that debt. And it goes for lawyers. In court, if you challenge jurisdiction or whatever you want to call it, and you get out of that fine by not going in joinder or not consenting, by not even stepping inside of their courtroom, and you don't consent, that debt goes to the lawyer. Somebody has to pay the debt. It just won't be you. Okay? All legal jurisdiction arises from the consent of a man or woman to be party to an artificial person name. I also wanted to tell you that each one of those public servants have a bond. And that's where people like us who are living beings who stand on our square and do not consent to their proceedings, that is where that debt will go for that cop or lawyer. That will come from their bond. Why do they have surety bonds put into place if this isn't so? Right? It's so that when somebody like us does not go through with what they want us to go through with, or it doesn't work in the favor of them swapping places and making us trustee, then they have to become the debtor, and it comes from their bonds. Okay? Even schools, public schools have surety bonds, which I'll be talking to you guys about too in later videos. I don't want to pile too much on you. I just want to give you the facts right now, and then we'll start moving into different processes as we progress into knowledge. Without consent, there can only be the presumption of consent. Okay? So, like I said, ignoring is not a good idea, because then they're just going to presume that you consent and they're going to move forward with their proceedings and send out warrants for arrest and things of that nature. So it's best for you to put on paper and have it notarized that you don't consent. And living men or women use their fingerprint as their signature. Okay? You can also use the beneficiary autograph. So when you rebut the presumption, they have no jurisdiction and cannot proceed. Any further action is fraudulent. To rebut the presumption, it is only necessary to correct a mistake in the name. That's it. And I already told you guys how to do that in the last study session video. YouTube video. So go and check my previous videos if you want to learn this. And everything's in order. So if you want to start from the beginning and work your way up, that is probably best. Jurisdiction is over the name. Liability is attached to the name. So correct the mistake in the matter of the name. So if you are acting as that name, then you become the owner. And owners are liable. That's why you want to own nothing and control everything, because when you control things, you have no liability. Liability and ownership go hand in hand, okay? So let's look on the blue side for administrative court. And administrative courts have no jury, while common law courts have a jury of one's peers. Administrative courts are under Admiralty Maritime Jurisdiction, which is commercial jurisdiction, law of the sea. Common law court is under common law people's jurisdiction, which is law of the land. Administrative court is incorporated courts. So they're only for corporations and corporate matters. Okay, that's why they address you in all capital letters. Common law court is for the living people, and it's non-incorporated court. Okay, administrative court is for dead entities, which is the all caps name. We already talked about the capital letters in the name and what they mean. Again, if you don't know what they mean, go and visit my previous videos where I break that down in detail. It's very important to know the difference between the spelling and why they even taught us this to begin with about how to write our names, so that we can join ourselves with the dead entity, right? They want us to be dead men. This is why they call it The Walking Dead. They make fun of us by making these zombie movies and things like that. Like, and people really take that literal, like, oh, it's flesh-eating zombies. No, that's you. You're a flesh-eating zombie because you eat flesh, literally, out here eating all of this flesh, and your brain is just gone, and you're just a walking dead because you're acting as a dead entity. That is what that means. Okay, administrative court is for artificial legal persons, while common law court is for natural lawful men and women. Administrative court is a corporate dispute resolution service for consenting parties, which means you have to give them your consent, whether it be implied or informed or any other type of consent. As long as you consent, they can proceed, even with you not saying anything. If you don't say anything, that is implied consent. Because if you don't say nothing, we're going to move forward. You're acting in dishonor. So keep that in mind. There are several different types of consent. I think it's about 5 or 6. You need to go know what they are. I talk about these in my private study session. I talk about this to my group. So you guys should already know what it is if you watch my videos on Patreon. I've already discussed this a long time ago, but I might have to bring it forward again on YouTube for those of you who are not in my private community so that you can know the difference between consent. Okay? Common law court is a constitutional venue to pursue justice for living men and women, while administrative court calculates. Administrative court calculates because it's all about collecting. Common law court is a court of record. It weighs evidence. We need evidence. So when you see those people going on these long trials, like murder trials and stuff like that, that is a common law court. They're using the jury of one's peers. They're using evidence against the person. They're presenting the evidence to everyone for everyone to see. So they're using a court of record, and the jury has to go and delegate or whatever you want to call it in the back room after the proceedings to say whether this person is guilty or not guilty. So they're using their common sense to come up with a conclusion and not just saying, oh, you owe, so we're going to arrest you because you can't pay the debt. We're going to put you in jail. So it's a difference. Administrative court is to settle the account in a commercial transaction, while common law court is to repair harm and loss suffered by injured people. Okay? Now, administrative court is administrative of contracts by consent, which are legal privileges or benefits prescribed in statutes, acts, rules, codes, etc., which I already broke that down to you guys. While common law court is upholding unalienable rights, lawful rights, properties endowed to living people, antecedent to the state. I always have an issue with that word. Now, administrative court is in commerce, while common law court is justice. Administrative court judges takes bar association oath to serve the bar. The bar is where the lawyers come from that are acting in administrative court. And none of that stuff is actually a real lawful venue. That is not a lawful association. That association is more like a membership that you pay to be in. It's a club of people who know secrets and they stay close. The Khazarians are all wrapped up in it. That's why most lawyers are Jewish. And this is just truth. This is not any racist or prejudiced statement. Okay? Judge is banker at the bench, which is bank in Latin. Okay? Common law court judge takes oath of office to serve the people. Judge, did you bring your oath of office? Okay? Administrative judges serve administratively, while common law judges serve judicially. It's a difference between administrative and judicial. Administrative court officers of the court have private surety bonds, which I was already talking to you guys about. Why do they have those put into place? Unless it's for the reason that I said. If you decide that you don't want to consent because you know that that is not you and you are a living man or woman and Article 3 court is not where you belong and you're not tying yourself into that debtor because you aren't a debtor, you're actually a creditor and you don't consent, then guess what? They're going into those officers of the court private surety bond to take out those funds because now they are acting as debtor. Okay? Common law officers of the court have public statutory bonds. Administrative court officers of the court have full commercial liability in private capacity, while common law court officers of the court have limited liability in public capacity. Okay? Administrative court is more like a country club. Like I said, it's like a and the reason why, let me break this down. So what it means by private capacity and full commercial liability, it is saying that these are they work for the corporations, these private corporations who are coming in collecting from people. It could be your rental, your rent, where you rent your home from. It could be where you purchase your home, your mortgage company. It could be credit card companies. Okay, they're taking you to court and trying to garnish your wages. Why are they doing that? Because they're privately owned and operated corporations that are acting in full commercial liability. These courts are doing that for them. Okay, I hope that makes sense. When it says on the common law side about limited liability in public capacity, it means that they're limited to certain things because it's for the public, for the people. So certain things they cannot violate over the people. Okay, it's also in common law court sovereign nations. So it's for sovereign people who stand on that square, people who act in sovereignty. because they know that they have unalienable rights. And administrative court is de facto, which means in practice. Literally, that's why they call it a law practice, practicing law. Because they're practicing. It's not real. They're practicing for the show, the theater of commerce. So when they go inside that courtroom, that Article 3 courtroom, they're going to act out what they've been practicing. Like actors, before they they film the movie, they have to practice and they have to audition, and they got to do the script, practice, remember the script and practice the movie before they actually shoot it. Same thing. And common law is de jure, which means in law. It's fact. Okay? So de facto, in practice, fiction. Common law is de jure, in law, fact. Okay? Jurisdiction is key. Your jurisdiction determines your standing or your lack of standing. And jurisdiction means, one, the power of a court to adjudicate cases and issue orders. Two, territory within which a court or government agency may properly exercise its power. And I want you guys to go see E.G. Rogars, or however you say it, AG versus Marathon Oil Company. This is from 1999, and it's 526 U.S. 574. I want you guys to go look that up because it's about jurisdiction. A man or woman who acts enjoinder to a legally generated artificial person created and controlled by the state has legal status in the Admiralty Maritime Commercial Jurisdiction. And this comes from the International Law of Sea. Okay, that's what that is, the International Law of Sea. So a man or woman who acts enjoinder, which I already told you about, you're living, and they send you a summons that has all capital letters, and you get afraid and you either pay the fine, go to court, whatever. That is you, the living man, acting in joinder. And joinder means you are becoming the corporation at that point. So you're trading in your unalienable rights for statutes, codes, and rules and law. What's the word I'm looking for? And you become the debtor. Okay, so you're switching out your creditor status to become a debtor, unknowingly though. But it's still it's still you giving your consent. Okay. Legal jurisdiction over a man or woman derives from consent to contract into legal fiction commerce. If there is no valid contract, there is no jurisdiction. The legal system pertains to the fictional theater of artificial persons. When a man or woman consents to act enjoinder to an artificial person, they cease to live in their private capacity, possessing unalienable rights and properties, and volunteer to act in a public capacity, granted revocable privileges and benefits. Hence the driver's license, which you guys should know by now is a privilege, because they tell you that. They tell you it's a privilege, and they revoke it whenever you don't follow their rules, statutes, and codes. They can take it right from you. However, that does not mean that they can take the ability for you to get in an automobile and travel in it. No, because you still have that right, because it hasn't been taken from you by the creator. Entering the legal system is by contract or legislation, usually via registration, licensing, certificate, securitization, or general deposit. In the legal fiction system, consent to contract can be presumed by silent acquiescence. Like I said, do not ignore these notices because that is your ignorance. At this point, you are silently acquiescing to whatever it is that is on that notice. Whether you can say, I didn't see it or I didn't get it. As long as they know they mailed it and they have proof that they mailed it to your address, they're going to follow through with whatever that notice says. Or it's not a notice because they can't send notices. Only you can. Only sovereigns can send notices. So that letter. Okay? So you have to act in honor and you have to actually tell them that you don't consent. Unless a man or woman rebuts the presumption of joinder to an artificial person. And that's what you have to do, rebut the presumption. All artificial persons are created legally without any inherent productive capacity and are therefore debtors by default and limited liability entities. They function as transmitting utilities to transmit human energy into commerce. Living people energize legal fiction commerce knowingly or unwittingly by deception, which is fraud. But you can't prove that to them. All you can do is stand on your square. A man or woman who lives naturally in their sovereign body possesses all their unalienable rights and powers, has lawful standing in the common law jurisdiction, the national law of the land. That's what that is. Lawful jurisdiction over a man or woman derives from causing unreasonable harm to a living soul. So again, murdering someone is, you should be behind bars because that is lawful jurisdiction. Harming someone's property, you should be behind bars. That is lawful jurisdiction. We are supposed to love our neighbors as we love ourselves, right? If there is no human victim, there is no jurisdiction. So a traffic citation that they are telling you were allegedly speeding, where is my accuser? Because I have the right to face my accuser. And the police, you're not my accuser because you're using a device. And that's even if you're actually using it, that most likely isn't calibrated. Most likely it isn't calibrated. So I need you to show me that you've done that. Where's my accuser? If there is no human accuser and there is no property with a human accuser saying that I damaged it, then there's nothing that you can do and I owe nothing. I don't consent. The law pertains to the real world of living men and women. Lawful jurisdiction is subject to the due process of the common law, whereby no crime is attributable to a man or woman unless they cause intentional or measurable harm to another man or woman, not reasonably caused by self-defense. So if you're defending yourself, hey, I'm defending myself and I have that right. I have a Second Amendment right to bear arms. And if someone breaks into my home, I have the right to defend myself, my home, and my property. So if it just so happens that I murder someone in self-defense, hey, that is my right. To prove a crime of harm, there must be an injured party willing and able to swear under oath to the facts of that harm upon penalty of perjury in a properly convened de jure court of record, which is common law court with a jury of one's peers, or witness testimony equally bound or irrefutable evidence. In any detention, seizure, or arrest, the accuser must have probable cause and or a reasonable suspicion that the accused is committing or is about to commit a crime against a human victim. The accuser bears the burden of proof. So when the police tells you that you've been doing X, Y, and Z, I need you to prove that, officer. You don't say that to the officer because you don't want to make matters worse, but if you have to walk into that courtroom, you know how to stand on your square. Okay? Any forced detention, seizure, arrest without a human victim by any public servant is coercion, arrest, treason, and a breach of their oath and fiduciary duty as trustee. Remember, they are the trustees. They just switch roles with us when we unknowingly join contracts, adhesion contracts. Okay? No legal or lawful matter can proceed without jurisdiction. Once jurisdiction is challenged, it must be proven. Hagens versus Levine, 415 U.S. 533. Go check that out. That is a court case about jurisdiction. Another one is jurisdiction once challenged is to be proven not by the court, but by the party attempting to assert jurisdiction. The burden of proof of jurisdiction lies with the asserter. That's McNutt versus GMAC, 298 U.S. 178, and Maxfield Lessees versus Levy, 4 U.S. 308. And then you have another one about jurisdiction, which is once jurisdiction is challenged, the court cannot proceed when it clearly appears that the court lacks jurisdiction. The court has no authority to reach merits, but rather should dismiss the action. That's from Mello versus U.S. 505 F2D 1026. Okay? And here's more. I always give you guys a lot of evidence to back up whatever I'm telling you about. Okay? Because I'm not making this up. I'm not one of those people that's going to give you something that's made up. There is no discretion to ignore the lack of jurisdiction or that lack of jurisdiction. Joyce versus U.S. 474 F2D 215. Jurisdiction can be challenged at any time, even on final determination. Basso versus Utility Power and Light Company, 495 second 906 at 910. Only you can challenge jurisdiction when you do not consent. A simple jurisdictional challenge can quickly stop any legal matter. I'm going to read it again. Only you can challenge jurisdiction when you do not consent. A simple jurisdictional challenge can quickly stop any legal matter. Okay. As a director and beneficiary of my legal person, corporation, trust, I give you 21 days to respond in writing, providing proof of claim with evidence as to your legal or lawful jurisdiction over me, failing which you will become liable for any damages I may suffer. Memorize this powerful sentence and keep a note of it. That's what you're going to write on anything that you don't consent with that is from administrative court. I'm going to read it again, but I'm also going to tell you more when I'm finished. Okay. As the director and beneficiary of my legal person, corporation, trust, I give you 21 days to respond in writing, providing proof of claim with evidence as to your legal or lawful jurisdiction over me, failing which you will become liable for any damages I may suffer. And that is where the fee schedule comes in. When you send that fee schedule, letting them know this is how much you're going to have to pay me if you don't do that, because I'm suffering. I'm suffering from these summonses coming in the mail with my all caps, with a all caps name on it. That is a corporation that I did not create. I am not responsible for anything connected to that corporation because I didn't create it. You can say this to legal actors face to face or write it on their legal offer document, any legal ticket, fee, penalty, tax summons, etc. This removes their presumption of jurisdiction and places the burden of proof on the claimant where it belongs. You may need to do this 3 times, adding, I do not consent to proceed until your jurisdiction is proven with evidence. So I'm gonna read it again because I know you guys want to use this. So this definitely works. So I just want you guys to know. You can say this to legal actors face to face or write it on their legal offer document. So if you are already in the process of going to court for foreclosure, anything where they're trying to collect from you or garnish your wages or anything of that nature, this is what you say. When the judge calls you up, asks you what your name is, you straight just say that. You do not tell them your name because you don't want to become enjoined with it. You say that and it's over. Or you're going to write it before you go to court. If you get summonses or anything of that nature, taxes, anything, you're going to write that and you're going to send it in. But you're going to get it notarized before you send it in. And you're going to make copies of it for your records. And that's any legal ticket, fee, penalty, tax summons, etc. This removes their presumption of jurisdiction and places the burden of proof on the claimant where it belongs. You may need to do this 3 times, adding, I do not consent to proceed until your jurisdiction is proven with evidence. Legal actors in commerce do not have legal or lawful jurisdiction, so they will be evasive. When they fail to respond, you can serve a notice of default for the record. You can also charge them for any damages you suffer, although do not accept them to be honorable because they're not honorable. They don't act in honor, but you still will send them that fee schedule. Everything that you'll be doing will be on the record. Okay? And I just want you guys to know that I go live every Wednesday at 5:30 p.m. Pacific time, 7:30 p.m. Central, 8:30 p.m. Eastern. Every week I will share information to help you free yourself because the reality is no one will save you but you. You are the sovereign, so you must act that way. Please like, share, subscribe, turn on post notifications so that you can be reminded of when I go live. And if I get more engagement, the more engagement that I get, the more that I will put my time into this, the more that I will share information for those who may not be able to afford to join my private community. You still can do this on your own, and I'm giving you enough information so that you are able to do that. Also, if you're new to my channel and you're seeing my videos for the first time, and this is one of the videos you just so happen to come across, if you are interested in getting a free information packet with a whole lot of information and books to get you started on your personal independent studies, just email me and I'll give it to you. My email is divinetrustbabies07@gmail.com. I have no problem with helping people who want to help themselves. So I'm not one of those gatekeeping type of people who are saying that you have to be in my private community for me to show you the way. If you want to learn on your own, that's actually the best way to do it. However, I do have a private community that assists those who may need a little more support. Okay, so if you want that information, if you want that document that I read at the beginning, any of those things, You know what to do, and I am not one of those who will not help. However, don't try to bless me with questions and all that kind of stuff and take advantage of my kindness, because I will shut you down. But I will help you as long as you're willing to help yourself by pointing you in the right direction and giving you information for you to study independently. If you like the way I teach, consider joining my private community. I have a Patreon and you can become a patron at patreon.com/divine trust babies. On Patreon, it's kind of like an informational forum. It's a whole lot of information posted, but you have to navigate it independently. Okay? If you are one of those people that need a little bit more support with examples and instructions in a private Telegram support group for that, you can join my DTB Academy at divine-trust-babies.trainercentralsite.com/course/divine trust babies academy. One day I'll figure out how to shorten these URLs, but for now, that's just what it is. And if you're just interested in accessing any of my past study sessions from my private community and you want to learn more from those study sessions, you can do so at divine-trust-babies.trainercentralsite.com/course/study-session-replays. Or if you're one of those people who just want to purchase contents and courses and don't want to be locked into any type of community and you rather do things independently, you can purchase those at linktr.ee.com/divine-trust-babies. And I want to thank you guys for lending me your time tonight and listening to this information to help you help yourself. Thanks for watching. Next week, I will be discussing declining to appear in the courtroom. Again, the more engagement that I get, the more information I will share. For those of you who may not be able to afford joining a private community, I will give you that information here on YouTube. So share this video with somebody that you think needs it. Even if they don't, just share it. And I appreciate you guys for being here. I appreciate your time. And I'll see you guys next Wednesday.